Good afternoon, everyone, and thank you for joining us. I'm Christina Fox, the Chief Executive Officer of TechAlliance, and I'm your host today. As the Regional Innovation Center for Southwestern Ontario, TechAlliance is the place for dreamers, innovators, and world-changing ideas. We're focused on building a globally competitive innovation economy that enables entrepreneurship, spurs accelerated growth, attracts diverse and ambitious talent, and new companies. And we do this with all of you in mind. Like today's webcast, we consciously seek vital and valuable content for our tech founders across Southwestern Ontario. We know that to take an idea from conception to building a business around it is extremely fulfilling, but can be challenging. Owning the IP helps differentiate you and protect your idea. Canada's IP strategy is designed to support innovation, stimulate growth, and create jobs across the innovation economy. At TechAlliance, we want to ensure businesses, creators, entrepreneurs, and innovators have access to the best possible IP resources through IP awareness, education and advice, strategic IP tools for growth, and IP legislation. We are committed to supporting entrepreneurs on their terms with the guidance they need most. And we're so pleased to be partnering with the Canadian Intellectual Property Office, and we know you'll find value in today's topic, protecting your intellectual property and bringing your creations to life. Before we get started, let me share a few key points about this webcast. Everyone is muted today. Please feel free to add any questions at any point during the Q&A or during the presentation to the Q&A feature located at the bottom of the screen. Today's webcast will be recorded and available after the call. And if you'd like to keep up with everything there is to know about Southwestern Ontario's innovation economy, go ahead and sign up for our weekly newsletter. The link will be dropped in the chat bar. So now I'd like to introduce you to today's speaker, Dumitru Olariu. Dumitru is an intellectual property advisor at the Canadian Intellectual Property Office. He has worked for more than 30 years in the Canadian Intellectual Property Office, an agency of innovation, science, and economic development Canada. First as a patent examiner, and now as an intellectual property advisor. Before that, Dumitru worked for 6 years in the electronics industry, and his background includes a Master's of Science in Electrical Engineering and an MBA. Being immersed in the world of IP on a daily basis, Dumitru can capably answer all of your questions regarding what to do and where to access information and resources when looking for support and to protect your creations. So we are so pleased to have Dumitru here with us today. Dumitru, I'm going to pass the time over to you. Go ahead.
Okay, thank you. So good afternoon all. Thank you very much for your kind introduction. I will present you this basic presentation about intellectual property called Bring Your Creations to Life, Learn Why Intellectual Property Matters. It's a presentation, joint effort of Canadian Intellectual Property Office and another organization specialized in intellectual property called Intellectual Property Institute of Canada. The agenda includes a brief presentation of Canadian Intellectual Property Office, CIPO. Then we will dive into why intellectual property matters, talk about the importance of acquiring and using intellectual property rights, and also about the intellectual property intelligence found in so-called intellectual property databases. Then we'll go and talk about main types of intellectual property in Canada and give you tips, examples. And towards the end of the presentation, we'll talk about intellectual property strategy. It works to have a very good intellectual property portfolio, but also you have to use that in sync with your business strategy. So we'll talk about this, how to develop an intellectual property strategy towards the end of the presentation. The presentation will end with the intellectual property resources. So a few words about Canadian Intellectual Property Office. It's a special operating agency of a federal ministry called Innovation, Science and Economic Development Canada. Most countries have a similar like intellectual property organization that deals with the main types of intellectual property in that particular country. The role of SIPO is to examine and grant intellectual property rights, good quality intellectual property rights. That's why we take care in delivering good quality products. What it means that the intellectual property rights issued, granted, registered by SIPO have a strong presumption of validity. They may be used effectively to enforce intellectual property rights in Canada. SIPO also provides a quasi-judicial function for trademarks and patents. What it means is that there is a so-called trademark opposition board and re-examination of patent re-examination board that will be used when someone who would like to challenge a patent and patent right is re-examined. SIPO is also known for its mandate to raise awareness and effective use of intellectual property, because organizations that are effectively using intellectual property system, they perform better, they attract investing much easier, they are more likely to be successful in their business and go and export their products and services as well. SIPO is also responsible of sharing the information that collects in their its databases, so people can extract valuable information, and I will go in further detail on this in the next slide. SIPO also has an international mandate to promote Canada's intellectual property interests abroad. So it interacts with the different international fora specialized in intellectual property, other intellectual property offices from other countries. So that's the main international activity of SIPO. What is intellectual property? Intellectual property is a creation of the mind. It covers inventions, artistic works, design, logos, and more. Probably it's good, you may categorize all these creations in technological and scientific creations that will be followed by an intellectual property right, or brands, or cultural related creations, and we'll go more in detail in the next slides. Here it's worth mentioning that ideas are not protected by intellectual property. So it starts with an idea. However, the form or the implementation of that idea is followed by intellectual property rights. Intellectual property is important because people give a lot of importance to intellectual property assets, and that's why when you own these assets, your offer is considered unique. Why should you care about intellectual property rights? First, because you get that intellectual property right associated with the creation that you had. You have an edge over the competition. It means that you have a say on how your creation is used. You may stop someone, for example, of using, making and selling your technological invention because you got patent for that. It also helps the reputation and goodwill with your partners and clients. You'll be able to trade your intellectual property right, and the clients, based on the fact that you acquired intellectual property rights to that creation, that product, for example, they will associate with a certain high standard, and that's why your reputation and goodwill will increase. So you can use your intellectual property rights to attract financing. A lot of investors will look carefully to see if you take good care of intellectual property assets. intellectual property assets are very valuable when they are used in sync with the business strategy. That's why a lot of people are interested in using the intellectual property portfolio and align the intellectual property strategy with the business strategy. We'll go in further details when we'll talk about IP strategy. And because you have that exclusive right to stop someone of doing something with your creation, because you own that intellectual property right, you are able to secure your markets. When you establish an intellectual property right, when you register an industrial design, for example, a form of intellectual property, or have a patent granted to you, you submit a document, and all these documents are stored in intellectual property databases. So you may extract valuable information from these databases. First, you'll be able to see if you are infringing in someone else's intellectual property rights. So you'll be able to avoid costly mistakes in your activities. You'll be aware of what others do, especially your competition in the terms of intellectual property. And you'll be able to extract valuable information that will help you focus on the right business strategy. That's very helpful. Let's talk now about main types of intellectual property in Canada. A few words in general. So you start with the creation of the mind, and depending on what kind of creation, you may get an intellectual property right. And we call intellectual property is almost similar to physical property. There are some differences though. As a physical property, you may sell it, you may trade it. However, keep in time that intellectual property generally is territorial. Also is limited in time. So you have to take care to maintain it and be aware when it expires. And another feature that is important is that all these intellectual property rights are not self-enforcing. So you should take care to police your intellectual property rights and enforce it properly when needed. So depending on the creation, you have these main types of intellectual property in Canada. Trademarks, when we talk about a brand, a sign that will identify and differentiate products and services from other companies. If you deal with the creations that is related to technology and science, like a product, process, machine, that it's new, useful, and inventive, you may obtain a patent right for that. The trade secret is any kind of confidential information that gives you a competitive advantage. Copyright is related to creations from the cultural field, and we'll go in further detail on that. Industrial design will cover the shape, pattern, ornamentation applied to a manufactured article. So these are the main types of intellectual property in Canada. You have more specialized types of intellectual property like plant breeders' rights, integrated circuit topographies, personality rights. We will not cover in this presentation. However, information on these main types of intellectual property you find on the CIPO's website, full guides, videos on the basics, and the full detailed information on how to obtain different intellectual property rights and establish them properly. Let's talk about trademarks in further detail. So trademarks are signs to differentiate product and services from other companies. These signs might be words, symbols, designs, uh, uh, tastes, even textures, moving images, modes of packaging, holograms, sound, scents, you name them. So the main characteristic is that they are able to identify and products and services and differentiate them and point to the producer. And people associate the quality of the products and services based on that particular sign. So that's how it works. And you have here examples of on the slide of the trademarks, Tim Hortons, Shopify, Canada Goose. They identify different products and services, and they are have a certain reputation, and people buy because they have established that association between the quality of the product and services and that particular brand name. When you establish your trademarks rights, you have the right to exclude others from using that particular sign. So in Canada, it's a combination of use and registration. What it means is that in order to establish your trademark rights or register them and enforce them, you have to use the trademark. It's quite important. Registration is not compulsory, it's optional. It gives you the advantage that you have an additional evidence of trademark ownership, and you may enforce it in Canada. Throughout the territory, it doesn't matter where you use it. When you register, you get initial 10-year protection, and you may renew it actually indefinitely if you'll use it every 10 years and pay the the maintenance fees or the renewal fee. It's quite important to use your mark as registered so you may enforce it easily. Otherwise, you'll have a so-called diluted trademark. It's good practice to market a trademark. I will give you further tips in the next slides. So keep in mind, trademarks are territorial. Registration is optional. If you decide to register yourself and you'll pay just the government fees, these are 330 if you pay online, the basic fee, and the renewal fee in 330 if you'll pay online as well. So further tips. Here we give you an indication of what we consider powerful word trademarks. So coin names like Kodak, Kleenex probably are the most powerful trademarks because it's quite difficult for someone to come close to them and sell products and services by the same name. So they have no excuse of using a similar like name. Dictionary words not related to the character are next in line in terms of powerful trademarks. And an example would be Apple, Roots, Indigo. What is less, I would put it this way, powerful trademarks are suggestive marks, chapters for books, Whirlpool for washing machines. Personal names are not recommended. Very hard to register. You've seen in the previous slide, Tim Hortons. However, if you can establish that your personal name, like Tim Horton, will work to identify products and services and will differentiate that in front of people buying your products and services, then you may say that you establish trademark rights and may be registered because you have that quality of differentiating your products and services by that particular name. Descriptive marks are not recommended, are very weak marks and very hard to register as well. Other tips on trademarks, we advise you to do a preliminary trademark search. You have on our website a so-called tutorial on how to search the trademark database, and I strongly advise you to use it. You may consider also distinguishing guise and certification marks. Distinguishing guise are a type of a trademark that refers to shaping of goods and their containers. You'll have an example later on. Certification marks are marks that are used to distinguish goods or services of a certain standard. And an example would be Woolmark design, owned by Woolmark Americas Limited, for example. So not all application gets approved when they are examined by the trademark examiner. You don't have to despair, because by using the trademark, your customers may associate that particular mark that you have with their products and services, and to differentiate from other providers. So you'll be able, you may show that you'll not create confusion on the market with your trademark, and you'll be able at a certain point in time when you will establish that trademark character of your trademark, you'll be able to register it. It's important to establish from very beginning who is the owner of the trademark, the company or the individual, and take care of the trademark title. Keep in mind that company name, business name, domain names are not trademarks unless they are used to identify products and services. So in that situation, they work as a trademark. Once you register, it's in your own advantage to mark it properly with R encircled, registered, TM if not registered. Let's dive now into patents. Patents are for creations from the scientific technological field. They are inventions. They may be a product, a process, a machine, a composition of matter, or that is, or improvements on all this that are new, useful, and inventive. That's how it works in order to have a patentable invention. The right is quite different than trademark right. You have the right to exclude others from using, making, or selling what you claim as your invention in your granted patent. In order to obtain that right, you have to apply, and the patent has to be granted to you. The term of protection is up to 20 years from the filing date. The invention has to be new when you file it. However, in Canada, United States, there are 12 months grace period. It's not advisable to use it. I mentioned to you trademark fees for patents. For example, if you decide to do it yourself, the front-end fees for a small entity are $750. Several patent tips. As for trademarks, you search the Canadian patent database, other databases as well, because an invention has to be new in the world. So you should consider searching other databases. It's a quite specialized domain in the sense of drafting, writing, processing the patent application with a Canadian Patent Office. So it's highly advisable to hire a registered patent agent or lawyer to do it on your behalf. So I mentioned can be an improvement to an existing product. What you get as a patent right, it's a veto power. So you have the right to stop someone of making, using, or selling. So that's how it works. It's advisable not to disclose it. The grace period is 1 year from the before the filing date of your patent applications. Other tips quite important to name all the co-inventors and establish that who has title to the patent. When we judge if an invention is inventive, we consider the knowledge of a person that is familiar with the field of technology. So if this person may say that, oh, why I haven't thought of that before, it means that it's inventive, your invention, so you may obtain a patent. The invention has to be submitted in writing, and you have to describe it, give full teaching of the invention, nothing more, nothing less, that you really invented. So keep in mind that the system, the patent system in most jurisdictions in the world is first to file. So what it counts is to file as soon as you develop your invention and are ready to patent. Before that, it's advisable to keep it secret. So you use that form of protection, trade secrets. It's any kind of information that may be kept confidential and gives you a competitive advantage. Maybe product related, like a product, a process, a formula. Maybe trade related, like the business plan, a list of potential clients, a list of suppliers. All this may be considered trade secrets. It's very important to keep it secret in order to have some measures in place to keep it confidential. We'll talk more about that. No registration is required, so it's not so expensive like for other forms of intellectual property. Protection lasts as long as confidentiality is maintained, and if someone else invents independently and obtain a patent, too bad, in the sense that they have the right to control the invention. So that's like a setback of the trade secret. And then it's advisable not to disclose before taking or considering patenting. Other tips, you put in place confidentiality agreements. Companies should have confidentiality clauses in employment agreements. You encrypt all the information. You set up passwords for protection of the confidentiality of the information. Lock and key, limit the number of individuals who access that information. Okay, now let's go to industrial design, another form of intellectual property that covers the shape, pattern, ornamentation applied to a manufactured article. So that's the creation. And as for patents, you have the right to exclude others of making, using, selling, exhibiting for sale that particular design for a limited period of time. You have to apply in order to obtain that right. So you have to register your industrial design, and you get the protection up to 15 years from filing. In terms of money, what you'll pay in government fees is you may obtain a design for a basic fee of $400, and after 5 years, you may maintain your industrial design rights for $350. You have to keep in mind that you have a 12 months grace period. So in the sense that your design has to be made public less than 12 months grace period, less than 12 months before filing date of your industrial design application. Several tips: you may search our industrial design database. Keep in mind that you cannot claim functionality for the design. It's just the way it looks. And if you obtain industrial design, and if you use that particular shape of container, for example, you saw in the previous slide the shape of Coca-Cola bottle, you may use that as a distinguishing guise, as a trademark. So it's quite not too complicated to file an industrial design application. You submit views of the designs that show the original features of the design. If you decide to go with a registered patent agent or lawyer, they will help you with the processing of your industrial design application and securing your industrial design rights. Copyright, the last important type of intellectual property that we talk today, it protects the cultural related works, maybe books, plays, sculptures, musical works. When you acquire that right, you acquire the right to publish, exclusive right to produce, reproduce, perform, so not just copy. The right is acquired automatically upon the creation. The duration of the industrial design is life of the author plus 50 years. And because Canada signed international convention on copyright, you may consider that form of intellectual property that is international. It costs you just $50 to apply yourself. So several tips here. It's easy to do. You don't have to submit a copy of your work. It's important to mark your work in order to show people that you established your copyright. So the proper marking will be C encircled by the name of the author and the year the design has been created. Keep in mind that you cannot protect ideas. The first author of the work isn't necessarily copyright owner, refers to full-time employees that are hired to create such works. They, according to the employment, by default, they have to assign the copyright to the employer. Copyright works for is associated to computer programs, software source code, maps as well, architectural work. So here I will finish this review of main types of intellectual property with this design that shows different creations, like invention might be covered by trade secret and later on by patents. Designs may be covered by two types of intellectual property and even more. Industrial design and trademarks first to come in mind. Then you have visual, literary, musical creations that might be copyrightable first, but you may use it to identify products and services, work as a trademark. Brands are usually trademarks, but logos might be considered artistic work as copyright, and shape of a container, as Coca-Cola bottle, may be considered first industrial design. So that shows you the main types of intellectual property you find in Canada. What's important is to make sure that all the intellectual property assets that you acquire are used in sync with your business strategy. So it's important to establish such a intellectual property strategy. The definition is a series of decisions and methods designed to maximize the contribution of intellectual property assets in achieving the business objectives. So I will give you an example of developing an intellectual property strategy. You start with an audit of what you have. So you acquire and develop and create an IP portfolio. You also make sure that you associate or you align these intellectual property assets with your business strategy. It's important to manage them properly in the organization. Also monitor how your intellectual property assets are used and how other what your competition is doing in terms of intellectual property assets as well, and also take steps to enforce your intellectual property rights. You usually ask questions like that for the intellectual property administration. Are you protecting your IP? Which IP you are going to protect? Are there any gaps between your what you have in mind in terms of the intellectual property assets, and you should take steps to acquire them? Then you are coordinating all these assets with your business strategy. So you ask your questions. Are you coordinating, aligning these strategies to work in sync? Then you take, you may ask yourself, are you have all your rights laid out? Do you have a strategy, an IP portfolio? If you are a bigger company, you should take care of how you communicate intellectual property strategy that we have to your employees. People from sales, from HR, from research and development, they are aware of how to deal with the intellectual property assets of the company. And also, are you monitoring your IP rights? Enforcing IP is also very important. You ask your questions if you are policing and search the intellectual property databases and take appropriate measures if you notice infringement. There are different possible IP strategies. The most popular would be that you protect a technical aspect. So you obtain the patent right, for example, and you try to, because it's an aspect that it's very important for that particular field of technology, you simply shut off your competitors. You may consider that what's important for your company is to focus on your brand value. So you'll go all the way to enhance the trademark protection of your brands. You may file protection for offensive purposes in the sense that you get patents, industrial design, and you don't trade them, don't sell them, don't issue licenses, you simply try to enforce them. You may also file because you would like to have freedom to operate, file intellectual property rights. There is no like standard IP strategy, so you may play and see what is suitable for your needs in terms of intellectual property strategy. A strategy might be not to file for IP protection, just disclose what you invented, and because you disclosed it, you may stop in that situation others from obtaining a patent. So a few words about intellectual property resources. You have on a SIPO website, IP4 Business, you have a toolkit, you have an IP strategy assessment tools, different videos that talk about different types of intellectual property from very general to very specific. You also have a suite of seminars and training services for businesses. You may enroll there and watch particular seminars and webinars on different intellectual property related topics. Here is the contact information of the organization that I mentioned in the very beginning. You have Intellectual Property Institute of Canada, that's mostly known as Association of Registered Patent and Trademark Agents and Lawyers. They helped us develop this presentation. You also have SIPO, and I advise you to go on our website and find the resources that I mentioned to you. Thank you very much for your attention. So I'm looking forward to your questions.
That's terrific. Thank you so much, Dumitru. We've got a couple of questions prepared from questions that came in prior to this session. And I see some of those questions have actually been answered by you. So what an expansive content spectrum you covered today, particularly as it relates to, bringing your creations to life and sort of protecting your IP. Thank you so much for the detail on a number of those different pieces. And I think what we'll do is shift to a couple of questions because we're making great time today. I'll start with my first, and that is, as Canadian inventors look to commercialize and enter the global economy, many would need to know whether or not Canadian intellectual property rights are valid abroad. Can you speak a little bit about the validity abroad and recommendations you make?
Yeah, intellectual property rights are territorial, most of them. I mentioned the exception that is for copyright, but even for copyright, there are different countries sign different international agreements, so you should take care to see what's happening in terms of intellectual property in each jurisdiction you are intending to export your products or services. So that's why we developed actually country guides, and they are quite popular. Country guides for US, for China, for India, for European Union. People are using them and try to understand what are the main differences between intellectual property in Canada and abroad. And you should adjust accordingly and be informed on how to use properly all your intellectual property assets and have some sort of global strategy if you want to go global in terms of selling your products and services.
Awesome, thank you. So being as many ideas and creations spur from individuals or smaller startups, a big consideration is often budget, and you've done a really terrific job of sharing some of those costs as you have looked at different components of IP. Generally, how much does it cost to hire an intellectual property agent for somebody who is early stage startup?
So we developed a page that will help you choose the right intellectual property agent and what question you might ask and what costs to expect. So for trademarks, probably $500 to $2,000 depending on the complexity. The most expensive are the patent and agents and lawyers. They cost between $5,000 and $25,000. Industrial designs, it's less expensive. As I mentioned in the tips, you probably might do it yourself, but it's advisable to do it professionally as well. Expect a cost of $500 to $2,000. Copyright is quite straightforward. I don't see any problem on doing it yourself. Keep in mind that it's good to take care of all your intellectual property assets professionally, so it's advisable to hire professionals to do all this job. And also, what is important to understand that once you get that intellectual property right, you should police it. So you have to budget properly afterwards, and by country as well. So the cost may get up quickly for a patent. So keep in mind if it's really what you need. Adjust your IP strategy accordingly and according to your budget. But the strategy you should have. It doesn't matter how big the company is. An IP strategy in sync with the business strategy should be there.
I like that you call it out. It doesn't matter how big the company is, that the idea of protecting your creation should and could start early. And as companies evolve and as there are more opportunities, they should continue to evolve the IP strategy with the business strategy. Are there any situations where you think that there's more than one type of intellectual property that might apply? I know you did show a graph of some of that convergence toward the end of your slides, but can you give us some examples of that?
Yes, most of the time when let's say you want to have a very catchy brand, you hire an artist to create a logo, and that's an artistic work. And if you use it to identify products and services, that particular logo works as a trademark. So you have dual protections. Probably it's the most popular protections that you can get. So when you think of a trademark protection for that particular logo, you'll be able to stop anyone of using that to identify similar products and services. And when you're considering copyright protection, you may have a say even if someone will put it on a t-shirt. So you may stop that or control that particular use of that logo as an artistic work because you own copyright as well.
Okay. There's a couple questions from the live audience today. One is really specific. Are computer algorithms or mathematical algorithms patentable?
Yes and no, or probably yes if they are interacting strongly with a so-called traditional patent subject matter. I mean, in this case, with the hardware. So, and they point to patentable invention. There are specialists who might help you decide if you have a patentable subject matter when you try to base an invention on an algorithm. But the basic protection for algorithm, for source code is copyright. It's a good practice to have a copy of what you created. And the World Intellectual Property Organization just launched a program where you can submit a copy of your work and will be dated and stamped, and you may use it as an evidence of what you created. As I mentioned, when you try to register your copyright in Canada, at least, you don't have to submit a copy of your work. So there is a gap here that might be filled by such a service offered by World Intellectual Property Office.
Okay. A couple of other quick questions, if we can. One question says, how do you ensure that the IP that an employee creates is transferred to the employer?
You usually take care of the employment contract. So there it should be a clause what will happen if the employee will create. In the absence of a proper employment contract specifying intellectual property rights, if you are hired to create something and you are a full-time employee, you own your intellectual property right to the employer. So the title goes to the employer, but it has to be an assignment, at least for patents. Your name will show up as an inventor. It has to be there in the patent document. However, you have to have as well an assignment from the inventor to the employer. And this assignment is part of the patent document. And because there is an assignment, the new owner, patent owner, or the company has to hire in Canada a registered patent agent or lawyer to process the patent application.
Okay. That's a great segue to, are there any concerns, or should there be any concerns when hiring a freelance patent agent versus working directly with your lawyer to save on costs?
We don't have such a terminology as a freelance patent agent. We talk about registered patent agents or lawyers or people helping you to write your intellectual and process your intellectual property application. So it's risky when you do that because we will ask you to name that person if you'll file a patent application, to name the person who helped you to write the patent application. However, it's your responsibility to draft it, write it, and process it properly. Registered patent agents and lawyers take that responsibility, and it's less burden for you. You get the maximum in terms of the quality of intellectual property rights. And it's much easier to enforce your rights because you have a very powerful intellectual property rights professionally done. And you'll find potential buyers much easier. The buyer will look carefully how professionally done is your intellectual property right. The danger, if I may continue just a bit here, in case of patents, if you file a patent application and claim your invention, if you disclose more than you claim, what is left is like giving away to the public. So you lose some of the protection.
Interesting. Okay, thank you for sharing that. That's good perspective from both sides. There's a question that came in that says there's an old trick where you print a copyright item and mail it to yourself and not open the envelope, so the post office stamps the date of processing. What is your comment regarding this to proof of date of existence?
Yeah, it works in some cases, of course. If you can put a copy of your work in a registered mail and you'll just open it, it will be an evidence of the date you created that particular work and the copy of the work as well. That's what World Intellectual Property Office tries to do, in the sense that they ask you for a copy of your work. It's securely stored somewhere, and just in case you need the proof that you created that particular work, they can supply it and you may use it in court.
Makes sense. And I see that we're almost to the end of the hour, but there are a couple more questions. So I'll go with this one that came in. Statistically, how successful has Canadian patent challenges been protected?
We don't have such statistics, but some people try to make other kinds of statistics that might be related to, as an answer to these particular questions. How many patents are followed by commercial success? So some statistics say that 5–10%. So keep in mind that all the others, 90%, are not followed by commercial success. However, that's the way that you can protect an invention. So it's a risky business. You should keep that in mind. Having a very beautiful patent and let's say broad claims of your invention, this doesn't mean that you'll acquire or achieve the business success. So you should keep that in mind.
Okay. Now we've had a bit of discussion now of using an attorney versus a patent specialist, some of the costs to file intellectual property. Are there any supports that you're aware of that help a founder through the journey or the cost associated with this journey? There is so much emphasis on creating Canadian IP and how precious that is on the commercialization and potentially the exit. Is there anything that you can offer, Dumitru, on how founders can resource more easily the costs associated with protecting their IP?
Yeah, our organization doesn't deal directly with helping you to pay for such costs. However, we have an information paper on how to pay for your intellectual property and what the other organization might offer in terms of products and services. Recently, Premier Doug Ford announced a program that will help build an intellectual property portfolio. You have to be an established company and have an intellectual property strategy, but that shows how important it is to be successful in the business and how much importance the government, provincial government, the federal government, through other agencies give to having in place an intellectual property strategy for your company.
And I think that goes to show even the importance of today's webcast. I want to offer my thanks to you, Dumitru, the Intellectual Property Advisor for the Canadian Intellectual Property Office. My apologies for opening our eyes to what we might need to consider and where to access resources when creating an IP strategy. We do know that this kind of knowledge is critical in today's intangible economy and is something that we're focused on both provincially and nationally. We invite everyone to join us for the second webcast in this series on intellectual property on October 15, when Dumitru is back for a deeper dive into patents. with the session called Inventing the Next Best Thing, Why Patents Matter. Thank you so much for joining us today, Dumitru. That's it, everybody. Thank you for joining us. Have an incredible day, everyone. Be well and stay safe.
Thank you very much.